Jesse, thanks for coming in. What can I do to help you today?
NGT is at the point where I really need to hire people. Up to now I've been doing almost all of the work and I've been outsourcing some of the coding overseas, but really it's time for NGT to get some people in. I'm not sure if I should hire people or get independent contractors though. If I do hire people, what do I need to know to manage them and not run afoul on any of the rules or regulation regarding employment law? I came in to ask about what are my options.
Well, there are all sorts of minefields in this area. Let me give you an overview of employment law. So, the first thing you need to know about employment law is this. I think the best way to begin is by giving you do's and don'ts of hiring and firing people, how you have to pay them, things of that nature. And then I'm going to talk a bit about the pitfalls that can come along, including discrimination issues. So, historically, employment law was always about being employed at will. People could hire or fire you as they chose. Either the employer or the employee could terminate the relationship at any time for any reason. That, however, has changed. Today, it is heavily regulated by both state and federal statutes that you need to be aware about. And I'm going to go over them with you right now. So, the exception to employment at will is if you have a contract, there's some public policy against doing it. But when you have employment at will, what it means is that for non-discriminatory reasons, people can let you go, or you can decide to move on to another job as you choose. And again, as I said, there are exceptions. Contract is the most obvious one, where you have an employment agreement. And the employment agreement has got certain factors in it that need to be clear. Now, if you have the normal worker, they're going to basically be covered by wage hour laws. These include things such as the Davis-Bacon Act, which is the prevailing wage, the Walsh-Healy Act, which was the beginning of minimum wages, and all sorts of discussion about that now with the cost of living having gone up. A number of people in the service sector, especially low-end service sector, a real push to increase the minimum wage. There's something called the Fair Labor Standards Act, and this basically extended wage and hour regulation to interstate commerce. It used to just be for intrastate commerce, in other words, across state lines. You also can't employ kids. The government says you cannot have child labor practices with certain special carve-out exceptions, such as in agricultural areas. But in general, the way it works is that you have to pay minimum wage, and if you have folks that are working longer than the minimum wage, then you got to pay them overtime. And there are certain employees that are exempt. And typically these are white-collar workers, executive professionals. And there is a tendency, especially in the world of startup, to say, hey, everyone's an independent contractor. But you can get into a real lot of trouble, especially with the Internal Revenue Service, because the Internal Revenue Service depends upon employers to collect, among other things, Social Security taxes, FICA, that type of stuff. And if everyone is on a 1099, and are considered to be independent contractors, then the tax rolls go down. And so they really try not to do that. But there are new overtime rules as of August 2004, which says that basically anyone that earns less than $23,660, working 40 hours a week, anything over 40 hours a week is entitled to overtime. Doesn't apply to blue-collar workers, does not apply to firefighters and police. But any service industry, and especially in the world of startup, absent an employment agreement, which you really probably can't afford to guarantee those salaries at first, you're more likely than not going to be looking at some overtime issues. Now, traditionally also, in the world of employment, labor unions were a big issue. In fact, if you ever want to read a really good book that gives a pretty good history of labors and labor unrest in the country and union action in the country, there's a book called The People's History of the United States by a guy named Howard Zinn. And his politics aside, it's actually a very good history in terms of the union movement. And really a lot of things that have gone forgotten in terms of how did we get to have the standards of employment that we have today, especially with some wage protection that's out there. It didn't happen overnight. It didn't happen automatically. A lot of it was frankly fought for. But more likely than not, you're not going to be dealing with union issues in terms of a startup. But for a lot of other industries, it's very significant. A lot of hospital settings have got very strong union workers, especially among nurses and physicians. A lot of service establishments are covered by unions. And there are a couple of big federal statutes that guide this. First is the Knowles-LaGuardia Act, and this says that folks can basically go on strike. And the way it did it was that before this act got passed, people go on strike and the employers would go to federal court and get an injunction enjoining or preventing the strike from happening, arguing that it was going to be irreparable harm. And of course, the conditions that caused the strike in the first place never got fixed. So the Knowles-LaGuardia Act basically reined in the ability of the federal courts to set injunctive relief against strikes. And then there's something called the National Labor Relations Act. And this allows the right of workers both to strike but also to engage in collective bargaining. In other words, instead of a single individual negotiating and contracting with an employer, the unions could collectively negotiate for all the workers at a shop that is unionized. Then there's also something called the Labor Management Relations Act, and it stops unfair union practices such as closed shops. You can't get in unless you are a member of the union, so it cuts both ways. And then the Labor Management Reporting Disclosure Act, and this regulates the internal operations of unions. So there was supposedly a check and balance, a check on the employers in terms of allowing unions in, and a check on the unions so as not to cause a stranglehold against companies. Unions can be organized in a company if an election can be held and it's shown that at least 30% of the workers will be represented. And the big issue, of course, is to get folks who are employed to agree to want to have a union vote. And that's where a lot of times union organizers spend their time convincing folks to allow them to come in to organize them. And they've been, in many instances, turned away. There was a famous case when Toyota was first operating some of their plants in the United States, having come from Japan, where unions wanted to get in. And the Toyota employees said, we have a better deal than you can get us. So Toyota did not become unionized. But unions also have represented good things and bad things for both workers and for companies. And as we see by the recent bankruptcy of General Motors, a lot of the issues were with the funding of pension liabilities that were all part of collective bargaining and part of union contracts. The bankruptcy, in essence, wiped that out. So again, it's like everything else in life, there's a competitive tension between unions wanting to get the very best for their employees and companies trying to hold the bottom line. And the best companies work with their employees. The best companies make their employees part of the solution as opposed to just a mechanism for getting the work done. And the best companies turn to their employees in terms of solving the problems that they have and working in true partnership. But it's not always that case, and the culture of the company that you want to build is really going to inform what would happen here. But back to unions, if at least 30% of the workers can be represented, then that's an opening for the union. There's something called the National Labor Relations Board, and that regulates the rights and obligations of the employers and the workers in the election process to see if a union is going to be allowed in. And each side can pursue their objectives, but cannot interfere beyond certain limits in other activities. Now, the whole purpose of having a union is so you can have collective bargaining. And this is the process by which management and labor negotiate how employment is going to carry out. What the hours are going to be, what the pay is going to be, what the benefits are going to be, things of that nature. And a good example is UPS recently announced that they're going to, for non-union employees, take away paying for spousal health care benefits. Now, they can't do that for unionized employees because the union has that in their management contract already. And the National Labor Relations Board will certify an exclusive bargaining agent for labor. In other words, this is the person that's going to be representing you. Both sides are required to bargain in good faith, but they don't necessarily have to reach an agreement. And if they don't reach an agreement, a number of things can happen. One thing that can happen is there could be strikes. There are two kinds of strikes. Economic strikes, and these are strikes over wages, and if it strikes over wages, a company can bring in folks to replace them. The second kind of strike is unfair labor practice strike, and this alleges that the employee has committed an unfair labor practice. So let's talk about some of the things that might constitute an unfair labor practice. Well, first and foremost is safety. The job simply wasn't safe. And this is regulated by something called OSHA, Occupational Safety and Health Act. And it is a federal law aimed at safety in the workplace. And if a workplace is found to be unsafe, OSHA inspectors can come in and can fine the company. And there are a number of government alphabet soup agencies, OSHA being the biggest one, Occupational Safety and Health Administration, that governs this. Then there are workers' compensation laws. And what this says is that employers are required to pay workers' compensation, in essence, insurance premiums, to help out folks who get injured on the job and to see that those folks who are injured by workplace activities are compensated. And this is regardless of the solvency of the employer. That's why, in essence, it's an insurance fund. It requires the employees make a claim against the insurance policy instead of suing the employer. It requires that most employers carry workers' compensation insurance. So one of the things that you need to know in terms of starting up, in terms of planning your budget, is you have to factor in the cost of carrying workers' compensation. Then there are income security, pension, and health plans. Now, the primary income security laws are for Social Security and welfare, and then there are private pension plans, and this is governed by something called ERISA, the Employee Retirement Income Security Act, and gives employees a vested right to receive pension benefits at a future date when he or she stops working, provided that your company still offers a pension. Most companies these days don't. Most companies have gotten rid of pensions, have moved it to 401ks or 403bs in the public sector. But if you are going to be hiring good people, you've got to expect to offer some type of retirement plan. Typically, it's going to be 401k, and it's going to be costs for administering that. You've got to factor into your budget as well. And you certainly have got to factor in Social Security, which means that you've got to, as you're paying your people, have a good payroll service that's going to take care of making sure that, among other things, FICA gets paid. And there is a contribution by the employee, but there's also a contribution by the employer that you need to factor in. And then finally, there's unemployment compensation. You need to pay into the unemployment fund, and then what happens if someone becomes unemployed, they make a claim and they receive unemployment benefits. Unemployment, fortunately, it seems to be starting to come down, but it's been at records high. Now, if you do offer that, and among other things, offer health insurance, which is going to be a requirement from now on. It's been discretionary up until now, but with Obamacare, it's now going to be mandatory across the country, even though, frankly, you don't want to work for someone that doesn't offer health insurance. There is something called COBRA. And this says that in the event someone gets laid off, there's a discontinuance of insurance benefits from folks who have been either voluntarily left or involuntarily left, unless, of course, it was for gross misconduct, that you have to offer the plan to them, for which they would, in essence, pay for their premium as opposed to you paying for it. COBRA's required if you have more than 20 employees, and typically it comes, you see it with group health plans that are offered through the company. Another pitfall is the Family and Medical Leave Act. And the Family and Medical Leave Act says that if you have more than 50 employees, you have to provide unpaid leave to employees to care for both a child, a spouse, or a parent suffering with a serious medical condition. You can't terminate that employee for taking leave on the policy, and they have a right to go back to their job or to a similar position upon returning from work. So again, you're going to have to, as part of your planning, take this into consideration. If you hire people, you will have to, and they opt to take family medical leave, and you need to fill that role with a temporary while they're on leave, you need to factor that in as part of your budgeting, as part of one of the things that you need to consider. Then, employees have got certain privacy rights. The reality is that more than 2/3 of employees use some type of electronic monitoring. You should never, using your work emails, send out something that's private or confidential, personal to you, because your employer probably has a right to look at it. But there are some laws that protect employee privacy rights. There's constitutional tort law, and there's an electronic monitoring law that the federal government has passed. But the reality is that, especially with email systems that are owned by the company, or any type of internet activity on the company's systems, you're more likely than not being watched, and you need to follow the protocol. Other types of monitoring, you can require folks not to take a lie detector and test if there is an ongoing investigation. Otherwise, it's prohibited. Drug testing. You walk into a lot of stores, like Best Buy, for example, and right on the door as you walk in, it says mandatory drug screening if you're going to be employed here. And so there's the right, basically, for the employer to basically do drug screening tests. And there used to be AIDS testing. Pretty much all states now have outlawed AIDS testing. Some of the more conservative states still allow it. Electronic performance surveillance. The reality is that you can monitor your employees to your heart's content as long as you tell them that the surveillance is going to occur. So if you put right in the employee policy manual, we review your emails, we check your internet web browsing while you're on work or using equipment that has been issued to you from work, so company laptop, that type of stuff, you can monitor them to your heart's content. And then, in hiring people, in terms of screening procedures, the question has to have some reasonable connection to the job that's sought. So this gets us into hiring and firing. And we're going to talk a little bit more about this when we talk about discrimination stuff in a little bit. But there are questions that you are not allowed to ask. You can't ask about, do you have children at home, or are you expecting? You can't ask age. You can't ask about sexual preference. You can't even you cannot ask questions that are meant to get around this. You really got to stick to the facts. And we'll get into this in more detail as you bring in more people and give you some guidelines to go along. But the reality is that you need to be very, very careful, not only while people are working for you, not to engage in discriminatory activity or activity that could give rise to a cause of action or a lawsuit against you, but also in terms of hiring people, you need to be very, very careful in terms of hiring them and not to engage in an interview process or an application process that could be construed to be discriminatory. And in continuing the multiple regulations that you need to know about, you also have regulations relating to hiring immigrants. And you are prohibited from hiring illegal aliens, even though this is a real political hot potato right now. But the Immigration Act of 1990 limits the number of legal immigrants into the United States. A lot of this is changing, especially with companies like Microsoft and Google lobbying to get more folks in. And if you're going to be in the world of a tech startup, then this is probably going to become an issue for you. So those are all, or not even all, those are a panoply of some of the state and federal regulations and laws and statutes that you need to know in regard to employing people, as well as how to hire and fire them. But that's all the ways that you can get in trouble with state and federal regulators. You can also get in trouble with your employees. And your employees, if they see you do something bad, can engage in something called whistleblowing. Now, what whistleblowing is that an employee tells a supervisor that there's unsafe or illegal activity, and the company does not follow up on it. They can then make a complaint to the regulating agency and actually receive, for all intents and purposes, a bounty for making that reporting. And so as a result, there have been some whistleblowers who have gotten very, very rich as a result of whistleblower rewards and end up with a contingency percentage of the whistleblower fine. And these can amount to tens of millions of dollars. And if they are discharged as a result of bringing it to the attention of supervisors, that can be considered a wrongful discharge or a wrongful termination, and they can be awarded back pay as well as reinstatement of their job. So you need to have in place safe arenas and safe methodologies for folks to come and say that they see something bad. And the reality is that there's an ethical quandary here. If an employee sees something bad, and they know that they might be the beneficiary of a very large whistleblowing award, isn't that going to be a temptation for them as opposed to reporting it through channels? So that's a brief overview of the employment law in the arena of hiring and firing, the things you can and can't do. Let's talk now about the discrimination aspects of it. And there are a bunch of federal anti-discrimination laws, the most important of which, frankly, is Title VII, the Civil Rights Act of 1964. There's Age and Discrimination in Employment Act, there's the Equal Pay Act, and there's ADA, the American with Disabilities Act. And we're going to look at each of these. Now, as I said before, Title VII is the most important. This is the one that prohibits discrimination in employment based on race, sex, color, religion, or national origin, and sex now includes pregnancy. And if you have 15 or more employees involved in interstate commerce, then it applies to you. If any company grows to any decent size, you can expect that this is going to be the situation. In addition to religious discrimination, employees have to reasonably accommodate an employee's religious practice. And the enforcement of this is by a federal agency called the EEOC, Equal Employment Opportunity Commission. Now, you don't even have to discriminate intentionally. You can also have unintentional discrimination. Now, intentional discrimination is what's known as disparate treatment discrimination. And in it, the applicant, typically the employee, has to first prove that he or she is a member of a protected class, and protected class is a very, very, very broad arena of folks, that they applied and they were qualified and they were rejected for a job, and that the employee continued to seek applicants after they were rejected, even though they were qualified. And then the unintentional or negligent, which is called disparate impact discrimination, is that a non-protected applicant, someone who's not a protected class, can sue an employer who tries to, in essence, do the right thing, integrate members of a protected class into the workplace at their expense. So it's a real dilemma. It's almost a catch-22 for an employer to face, with both of these causes of action being available out there to folks that might apply to you. So let's talk first, though, about discrimination on race, color, and national origin. And Title VII says that employment policies that either, if they're intentional or negligent, that discriminate on the basis of race, color, or national origin are prohibited. And company policies that discriminate are illegal. They have to have a substantially demonstrable relationship to realistic qualifications for the job, all with the exception of race. So in other words, you can have some discrimination if basically there is a bona fide reason for it, such as, and we'll get into this a little bit later, the job requires that you have certain physical strength in order to lift boxes, that type of stuff. But this goes into the whole notion of reverse discrimination, and there have been a number of cases where, especially in the arena of union workers, that folks that are a non-protected class, which typically is white men under age 40, suing that even though they had better scores, let's say, in applying for a police job, they were bumped in favor of folks who were minority background who did not have as good scores. So, based on religion, if there's a sincerely held religious belief that interferes with the work, the employer must reasonably accommodate the religious practice of his employees, unless it would cause undue hardship to the employer's business. So, if you have an employee whose religion prohibits him from working on Saturdays, and that is your best and most busiest day, you have a dilemma in terms of, do you need to give that employee reasonable accommodation, or even if you can give that employee reasonable accommodation. Discrimination based on gender is basically you can't have sex discrimination in the workplace. So you can't classify jobs as male or female unless you can prove that gender is essential to the job, and I'm going to suggest to you that in this day and age you cannot do that. Again, the plaintiff or the person who was trying to get the job has to show that gender was a determining factor in the hiring, firing, or lack of promotion. And you don't necessarily have to fire someone in order to get in hot water. You can have an issue with what's known as constructive discharge. And that's where the employee actually leaves the job voluntarily, but they claim that they were constructively discharged because the working conditions that the employer caused were so intolerable that a reasonable person would feel compelled to quit. And this applies to any one of the Title VII discrimination things that we've looked at. And that also, even though Title VII does not specifically mention sexual harassment, the U.S. Supreme Court has interpreted Title VII to include sexual harassment. And there are two forms of recognized sexual harassment. One, hostile work environment, which we just covered, that the conditions were so intolerable that someone would leave. And the second is a quid pro quo, sexual harassment. So hostile work environment occurs when the workplace is permeated with discriminatory intimidation, ridicule, insult, that type of stuff. So the off-color jokes, among the workers in the group, or the guy who has the sexy photo screensaver would fall into this category. Or hazing can be construed as basically sexual harassment. And if the conduct is offensive to a reasonable person as well as the victim, and it's severe and pervasive, in other words, it's not simply a one-off, then you can show that there was that kind of discrimination. You could possibly face damages. And again, these are the types of things where there are a lot of lawsuits that succeed on these very grounds in companies. So what do? Well, the first thing you do is you don't allow these types of behaviors to occur. You make it very clear that if people engage in discriminatory behavior in your workplace, that they're going to be disciplined, including up to termination. You also put into place training that people don't engage, learn what this type of behavior looks like, so that will hopefully not engage in it. You also put into place very strong written policies of what is and is not allowed. And again, the issue you have is people will be people, what's innocent versus what's discriminatory, but it's a real minefield out there, and you need to be aware of it. Now, quid pro quo is the more direct form of sexual harassment. This is where the supervisor demands sexual favors from a superior, from a subordinate, in exchange for some workplace benefit. And even if it is carried out outside of the premises, outside of work, an employer can be liable for quid pro quo activity. So clearly a no-no. But it doesn't have to necessarily be by a supervisor to a subordinate. It can be by coworkers. Generally, an employee is going to be liable if a bunch of coworkers are harassing someone and the employer knew or should have known and failed to take action. So this is where you want to really put into play things such as the employee policy manual, the training, and just a no tolerance for this type of thing. And you can also, believe it or not, be liable for harassment by non-employees. If you are working with a vendor who engages in harassing attitude and harassing behavior with your employees and you don't put a stop to it, then you can be held liable, even if that vendor does not actually work for you. And it can happen in online environments, through chat, email, blogging, that type of stuff. You can avoid liability with prompt remedial action, and this is why the recommendation is that you want to put these types of programs into place in terms of training, in terms of written policies. And you can make it a policy, you should make it a policy, that if the company computers are used to distribute offensive material, then that is grounds for discharge. So, what are the remedies under Title VII? Well, the liability can really be extensive. A successful plaintiff can receive reinstatement. They can receive back pay, and that back pay can be a big price tag if the case took us several years to come to fruition. They can receive retroactive promotions. In addition, and over and above all that, they can receive damages. Damages for intentional infliction of emotional distress. Now, there's also age discrimination. And this is called the Age Discrimination Employment Act, ADAA, and it says that individuals over the age of 40 cannot be discriminated against in favor of younger workers. And this is a real issue today because the two largest groups of the unemployed today are folks that are just out of college, but also folks over age 55. And the thought process here is pretty straightforward. If you want to turn a company around fast, there is no question that the typical company spends most of its money in terms of employees and benefits. That will typically amount to about 30% of the overhead of a lot of companies, if not greater. So what's the fastest way to turn a company around that's in distress? Well, lay people off. And who are the most expensive employees? Well, typically the older employees, because they have the highest salaries, higher vesting, benefits, all that type of stuff. So there is a real temptation to cut those folks and bring in younger people who will work for less money. But you do that, you violate ADAA. And you need to be careful not to engage in that. That said, I'll give you a war story. I know of a company, who shall remain nameless, that managed to lay off everyone that worked for them over age 55. And the way they did it was that they set up a wholly owned subsidiary. They transferred everyone that was over age 55 to that subsidiary. So the subsidiary, those folks now work for the subsidiary, and then they just closed the doors to the subsidiary. Since it was the entire company or the entire subsidiary they're closing, it did not violate and it was not construed to be discriminatory, despite the fact that a lawsuit was brought on that very point. So ADA says, you shouldn't be replacing older workers with younger workers. The employee must prove that the discrimination was based on age bias. And the bigger the age gap, the more likely the bias. And there are exceptions, though. State public employees are not covered by ADA. And you're going to see that a lot of what we're talking about is things that cover private companies, but not necessarily covering state or federal agencies. Then there's discrimination based upon disability. And the Americans with Disability Act requires that you offer what's known as reasonable accommodation to employees or applicants with a disability who are otherwise qualified for the job that they seek. and the duty of reasonable accommodation ends at the point where it becomes an undue hardship. So it's a real judgment call as to what this is. But if you have someone that's completely qualified for the job, but has some type of disability for which you can give reasonable accommodation through the use of technology or through flex ability to work from home, things of this nature, then you can't discriminate against them. Now, to prevail on a claim under the American Disabilities Act, the plaintiff has to show that first they have a disability, clearly, that I otherwise qualified for the employment, and they were excluded solely because of the disability. And you have to, if you're an employee bringing this type of lawsuit, an applicant bringing this kind of lawsuit, you must first go through an administrative process with the EEOC. You must exhaust that administrative process before you can bring a lawsuit. So what do we mean by disability? Well, it's typically defined as physical or mental impairment that substantially limits one or more major life activities. There has to be a record of such impairment. In other words, it kind of just occurred yesterday, and it has to be regarded, the employees have got to regard as having such an impairment. And it's a case-by-case basis. So the reason for the administrative process is that that's what allows it to be treated on a case-by-case basis and decided. So what's a reasonable accommodation? Well, example, wheelchair ramps, flexible working hours, improved training materials, technology, things that help. And this includes even in job applications and in pre-employment physical exams. If the person has got a disability, you've got to offer them accommodation even at that time. And hostile environment has been allowed by some courts under ADA. Even though the ADA doesn't expressly allow suits for hostile environment, courts have said no. If we find that the hostile environment led to a constructive discharge, and that the person left because of a hostile environment centered around their disability, then we're going to allow that lawsuit to go forward. So far this all sounds really bleak if you're an employer, but there are some defenses to employment discrimination. And the four basic types of defenses are that first, it's a business necessity; second, that there's a bona fide occupational qualification; third, a seniority system; and fourth, after required evidence of employee misconduct. So let's take these one at a time. Business necessity basically says that the employer demonstrates that the job qualification is reasonably necessary for the legitimate conduct of the employee's business. And it's a defense basically to disparate impact discrimination. So if, for example, you show that the applicant or the employee must be able to have certain physical capability, then you could make a claim for business necessity. Closely related is bona fide occupational qualification. It requires the particular skills necessary for the performance of a particular job. So if a specific degree is required, or a specific licensing is required, and the applicant doesn't have it, then you can use this defense in terms of against a discrimination case. Third, seniority systems. And this is the one condition that distributed job benefits over the length of time it works out for folks that are older. And it's a fence. If it's a bona fide system, it's not designed to evade the effects of anti-discrimination laws, but basically said that we're going to award people who've been with us for a long time and give them the next ranking up. Now you would think that this would be common sense, but is an arena that the courts have ruled on lots of times. And then finally, if after the discrimination suit begins, the employer finds evidence of misconduct after the fact, after the lawsuit has begun, while they were there during their employment, then this after acquired evidence can act to limit the liability. In other words, if we had known that this employee was engaging in this misconduct, we would have discharged them anyways. It limits your damages. It doesn't necessarily get rid of all the liability.
That is a lot of stuff. So what would you recommend?
Well, again, how about I task the firm's associates with researching what your options are and have them prepare a written memorandum of what you should do. They can have the memorandum prepared by the end of the week with their detailed recommendations, and then you can go from there. How's that sound?
That sounds great. Thanks for having me in today, and I look forward to getting that memorandum.
Sounds good, Jesse. It was great seeing you too, and we'll get right back to you as soon as we have Ray.